Hi, good day everyone. I am Sophia Bryan, attorney at law. I'm the managing attorney at the Law Boss firm, and our mission is to help Jamaicans at home and overseas build and preserve their legacy through real estate and estate planning. In today's video, I'm going to be answering some of your questions around land in Jamaica, as well as a bit of family law as it pertains to how you, as somebody living overseas, can get divorced from a Jamaican, or as a non-Jamaican married to a Jamaican, what the process is for you to get a divorce here. So I would have shared a little bit about me just to indicate, how am I uniquely qualified to be able to answer these questions. As I said before, I'm an attorney at law, licensed to practice in the island of Jamaica. I am also somebody that holds a real estate license as well as a financial advisor license. So this combination of knowledge and skill sets puts me in a unique position to be able to guide you. So my firm primarily helps Jamaicans who are overseas. Some of our clients also do include non-Jamaicans that have transactions pertaining to Jamaicans. Right, so let's talk a little bit about the last issue that I would have mentioned. How do you go about getting a divorce if you are married to a person who is overseas? Let's look at it from that angle first. So in Jamaica, we have what's called a no-fault system. So it means that you don't need to demonstrate any ill intent or anything of that nature in order to secure a divorce. We have a no-fault system. As long as you would have indicated or demonstrated to the court that you've been separated for a certain time period, in our case over a year, and you've been married for at least a year, and a year has passed since you've separated, that's the only thing that you need to demonstrate to the court in order for you to get a divorce. You also are going to be asked if there has been any attempts on your part to reconcile. If an attempt has been made to reconcile, that still does not, deter or prevent you from getting your divorce. So if you are married to somebody that's overseas, it doesn't matter once you decide that you want to be able to move on. So how do we help our clients who are married to people that are overseas? Well, importantly, if you know where they live, if you can, their address, personal services is an important part of our process. So the other party has to be served personally. So once you know what their address is, you find the relevant process servers who are in your area to serve that person. However, like some of clients that I've helped before, they don't know where their partner is and they don't know how to find them. And so then you would make applications to serve them in a different way, and that does add another layer of complication to the process, but it doesn't mean that it can't be done, right? It's just another step that you have to take. So a lot of persons have the misconception that if the other party doesn't sign, it means that the process can't go through. That's not the case. We have a no-fault system in Jamaica, and so once you have indicated that you've been separated for a year or more, the other party does not have to sign anything. They don't even need to acknowledge service if they don't feel like it. It just matters that you can communicate or demonstrate that you've served them, and once you have served them, that is it. You don't need to do anything else. So the person doesn't need to hold a stick over your head to say, oh, I'm not signing the paper, because they want to hold you hostage to a relationship that you're no longer a part of, right? If you are a non-Jamaican and you're married to a Jamaican, you can still get your divorce in our jurisdiction, right? The only thing you'd have to prove is that your partner still maintains Jamaican citizenship, and you can proceed with the process in our jurisdiction. And this is especially helpful for those persons who they're married to the Jamaican person, but they continue to reside in Jamaica, they may have moved. I know of several instances where persons would, shortly after getting married, actually just almost as though they fell off the face of the earth. You know, their partner can't hear from them, the number that they would reach them at, it's not available anymore, or, you know, once the filing process has started or it has reached a significant, can't hear from the individual anymore. And, you know, people tend to try and hold on to faith in a sense because of the shock. And then after a year or so, when it's obvious that the person is not returning back to the matrimonial home, and they want to move on with their lives, and they'll reach out to somebody like myself. Now, as a firm that primarily does real estate related transactions and estate planning, why do we entertain matters related to divorce? Well, the reality is, if something were to happen to you and you're still married to a particular person, if you didn't have a will, that person who you're still married to, regardless of the status of the relationship, that person would be entitled to managing your estate, especially if you didn't have a will. So your spouse is one of, if not the most important. Oh, cool, thank you. Your spouse is one of, if not the most important person in your life. And so if something happens to you, God forbid, you have to be rushed to the hospital and somebody needs to make a decision about whether or not the plug needs to be pulled, would you want somebody that you're no longer in a relationship with, that you no longer care for or no longer cares for you, have the final say in whether or not the plug is pulled? I don't think so. Right? Would you want somebody that you're no longer in a relationship with to be the person that's managing your estate? So that is a very important step, because the reality is, if you are married to somebody and you leave them out of your will, right? Whether or not they win is one thing, but they have a basis to challenge your will, because why would you write your spouse out of your will? And I know of instances where, a lot of instances in Jamaican case law where people have challenged wills, you know, the validity of a will, because the wife or the husband was left out. And so you want to go out of your way to make it clear that I'm not involved with this person anymore, and the divorce is the only way really to demonstrate that to the public. Now, what if you are gonna go through the estate planning process, and for you that involves getting a will? Hi, good afternoon. Thanks for joining Nikki Customs, Custom Inc. Great question. What if the husband has a side woman and doesn't put her in the will? All right, so I want to tell you why that's a great question. So under Jamaican law, nice to see you too. Thanks for joining the live. So if the person has a side woman, that's a good question, and doesn't put her in the will. All right, so in Jamaican law, you can only have one spouse, right? And we in Jamaica, our law recognizes common law unions. So common law means you've been living with somebody for 5 or more years, right? So that's the requirement. Not that you have a boyfriend or have a girlfriend and you visit each other from time to time. If you live together. So I see people, I know of people running down spouseship. It doesn't work that way. There's a 5-year requirement, right? And you have to be living together consistently. It can't be a visiting relationship. So if you are in a situation where you've been living with somebody for 5 or more years, then that person is considered a spouse only if they are unmarried, right? So if there's a side woman or a side man, right, that everybody probably knows about, they see them together, etc., you know, they go to events together. If that person is still married to somebody else, it's the person that they are still legally married to that has a right to anything, right? So, you know, people who are on the side need to be careful. What if there's no will and the wife don't want to stay the process Yeah, I've seen instances like that, but not in relation to like a side where the individual maybe has children, older children, and the wife doesn't want to have anything to do with the process in court. So you get first priority as a spouse. So if you decide that you don't want to live up to that responsibility, then fine, somebody else can apply to the court as the administrator. But if the wife decides that they want to be a part of that process, nobody can stop them, right? And it's a person that they're legally married to. So the side person would be in a very precarious situation, and it's usually the side person that's they're during the last days, and they're put in a bad position because at the end of the day it's the wife or the husband that has the final say. And if they decide that they're going to stand up to their responsibility to manage that person's estate, especially if they have something to fight for, then there's nothing that can be done to prevent that, right? So people have to be very careful. I think I may have seen. Yeah, so if the spouse doesn't want to act, if the husband or wife or the person that they've been with for 5 or more years doesn't want to act, then fine. But in the case where they have like older children, for example, and they were married to the person that they were living with, that person would have to prove to the court that they in fact were a spouse, right? There was a case in Jamaica recently where a woman thought that she was a spouse. Turns out that he was probably in another relationship, and the man said that's not his spouse, she's not entitled to anything after the relationship. Okay, battery going. All right. How do I add somebody? How do I do that? Okay, all right, I added you. Okay, go ahead, you can ask the question.
Good afternoon. So today would make it on 2023, the 6th of October, my father was met his demise.
Okay, my
So
condolences.
yes. So the thing is, his first child, he start the process of getting a divorce.
Yeah,
Now the wife, no, they separate, legally
yeah,
separate. She moved to another country entirely.
yeah.
And when my uncles went to his lawyer and checked on things, they said that legally she's still the wife. So the divorce didn't come true. Now I tried to do a little investigation myself, and everybody saying that they don't see anything submit at the Supreme Court and all of that. No, the law is so funny and stupid. No, the fact that they have started the process, should that count for something?
It really doesn't count. To be frank, what you would have to do is probably first the person. So, like your siblings, you and your siblings, everybody can come together and decide that you, for example, would be the person to apply for estate administration. Since it has
Because
been so many years,
yes,
you
and
could
when
put
I
the art.
asked her,
Yeah,
when I asked her, she said that she's still waiting on the death certificate, and she cannot do anything. She can't do anything, and I'm like, if he didn't leave a will that any of us is aware of, and when I asked her, she said you need to find legal advice. You need to get legal advice on the matter, and basically she's saying that it's not my father's house, it's their house. I say yes, but if you're, because they're supposed to have a child together, and I'm saying if your child is entitled to stay at the house, why wouldn't I entitled to stay at the house?
right.
Since she said no, I need to go get legal advice on the matter because I got it all wrong. I'm
Okay.
saying if I make it known verbally to her, I said when you start the process into his estate distribution, my name should be mentioned. She said no, she don't have to do that because the court would automatically know who and who's supposed to be there. I
No, the
said
court
no,
wouldn't
I don't care.
automatically know.
I said no, I don't care about that because she's asking me about another girl that's supposed to be is my sister. I said first thing she has told me that my father name is not on her birth certificate. She said his name is not on her birth certificate. I said no. She said
It doesn't
no.
matter.
Yes, she said well she don't know about that. And I mean it has been years. I can mention yet his name to you. His name is Gibbs Williams, the vice principal
No, you don't have
of
to call anybody's name, and you can just speak generally and I comment. You don't have to call
yes,
anybody's name.
but when I call his name, well, all right, whether or not, the fact is he wasn't a pauper.
Okay.
He wasn't a pauper, and if you as the wife who left him start divorce process, if you felt entitled to all his inheritance, why shouldn't I as his child be entitled to something?
How many children did he have? Or
I,
how
I
many?
am not certain because he have some that he did not tell anybody about. I start the process. I wanted to start the process to go through the registrar general to see how many children is registered in his name. And my aunt told me not to do it. He said that if my father wanted us to know, he would have told us. So if he not tell me to leave it alone, and I left it right there and then.
Well,
But
that's probably not a bad suggestion. So in
yes, so I left
or
it.
thank you, Sleepy, for saying that this is not official legal advice. This is just general information, guys. There is no attorney-client relationship being established here. Somebody just sharing their
Yes.
scenario, and I'm giving an input. So under our law, there is a tier system, if you will, just using that word loosely. The spouse has first priority. So in this case, a married person, so the divorce was not completed, so they're still married, right? So the wife would
Yeah.
still have priority. Then there's children, and then it goes down from there to other half siblings and other full blood siblings. So the reality is, if the spouse decides that they want to act, then they have the full authority to do so. However, if the children who are adult children realize that the spouse is not willing to act, then they can step up and, however, just be mindful of the fact that everybody who you know of has the authority, should be served or should be notified about the
Okay.
process. And then from there, if they have any sort of objection to the process, that can that can be communicated to the court. However, if they communicate some sort of objection, that may or may not be a good thing. So the reality is, you said that the person was not a pauper, but the only real way to be able to investigate what they really owned is to have the authority as an administrator of the estate. So with being the administrator, you can write to tax office, you can write to the banks, and other institutions for them to do an investigation as to what assets the person possibly owned. As it relates to a death certificate, I think everybody should know this. It really takes nothing to apply for a death certificate. RGD is fairly advanced now. You literally can go online, and if you don't have the information about the person, you can go inside, pay for somebody to do a search for you, or you can, once you have the pertinent information for the person, their full names and first, middle, and last name, where they last lived, that can put you in a position to get a copy of the
All
death
right.
certificate.
So correct me if I'm wrong. So I could apply as administrator in order to get his asset distributed, right?
Yeah, so you could apply as a child, as an adult child, but remember that once you go through that process, you really have to notify everybody. So
Yes.
so say for example, you know that the person has 7 children. You have to demonstrate to the court that you served or you notified all 7 children that you're the person applying for administration. And
All
if
right.
you know for a fact that the spouse is alive, for example, you have to take steps to communicate with the spouse. That's the right thing to do. Communicate to the spouse that you're
All
applying for
right. So
administration.
if all right. So if I apply for administration and somebody object it, what would that mean?
It would just mean that their objection could be maybe they're gonna suggest that you're not a child of the person or you don't have the right, and then you would have to communicate to the court that you are in fact have a right. So perhaps obviously a birth certificate would be ideal, but I'm sure there are persons in the community, mature persons in the community that could give an affidavit to say, yes, I know that that person is the father because of, I saw them, for example,
Okay.
taking them to basic school or prep school, or I used to see them playing together every Sunday evening and he would buy ice cream for her. That's an example. So the name on the birth certificate is not the only way to prove that you're an heir of somebody. I mean, it's a great thing, but I mean, in Jamaica, how many mothers actually took the step to
Yes, true,
add the
true.
father's name onto the birth certificate, whether it was because of animosity at the time of delivery, or
Yeah.
maybe they just didn't have the knowledge that that would have been an important step. Or I mean, there are instances where the woman didn't even know who the appropriate father, So there's a myriad of reasons why that would not have happened, and so that can be the only basis to determine whether or not somebody is actually the father of a child, right? So
Okay.
but in terms of support, this is a main area for us. Just as a general knowledge, the legal fees associated with estate matters is between 6 and 12% of the value of the estate, and so some people have an intention to sell some other assets to cover their legal fees, and some people don't. So you'd have to be clear in your mind how you'd pay the legal fees to deal with that. But there's always legal aid, of course, if you have a financial challenge.
Okay.
You
So
said something earlier.
I could actually get legal aid to help me through
I
this.
think so. I think normally law school legal aid clinic helps persons.
All right,
I
agree,
think they
right,
do.
Dasha.
Yeah, normally law school legal aid clinic. But you said something earlier that I wanted to speak about. I think it's a very important point. And it would allow us to go into another topic around land and title. So you were saying that the wife was saying that it's not his property, it's their property. And
Yes.
so to me, it could suggest two things. It could suggest that one, they bought the property as joint tenants, or he
Yes.
added her name as a joint tenant. And if that's the case, there's something called a right of survivorship that would apply. So the right
So
of
it would
survivorship
be
simply means that once one person passes away, it automatically goes to the other person. But
okay.
there's another way where they may have bought it together as tenants in common, or he added her name as a tenant in common, meaning that she only has a share of the property. And it could be that because she only has a share of the property, she's probably not motivated to do the probate, or it could mean that the right of survivorship applies, which is why she's not motivated to do the probate. We don't really know. Not probate, grant of administration. So we don't really know, but tenants, the way how you set up the ownership of the property is very important. Whether it's tenancy in common or joint tenancy, people really need to give that some proper thought, right? So joint tenancy means right of
Listen, like I
survivorship,
right up the road now, please.
means that it applies. And then if it's tenancy in common, meaning it can be like a 50-50 split or a 60-40 split, or maybe the person only has a 10% interest, whatever the case may be. So even couples looking to buy property together, or family members looking to buy property together, just bear in mind the notion of tenancy. Joint tenancy may be applicable where, for example, a mother and their child, and the mother is like a senior citizen, and they know the plan is for their child to automatically own, then joint tenancy may be applicable here. But if it's a case where you have a long life ahead of you and you want to be able to have the value in the property to use for your own personal use, so say you're a business person, you want your children to have access to the equity in the property, but you also want to be in a position to have access to the equity in the property, then you may want to do tenants in common and indicate a split, right? So yeah. All right, Miss Custom Inc., thanks for coming on, and feel free to reach out to me. If you need more personalized guidance, we can always. So one of the things that my firm does, our consultation is very different from the typical law firm. So we don't just do a chat or a quick conversation in our consultation. We actually give persons a roadmap, and it's actually a strategy session. So if you do a consultation with my office, if you decide that you're going to do it yourself, the information that I share and the guidance that I provide can put you in a much better position to confidently take the next best step. So it's not just a quick call on the phone. We generally do them via video call so that you can have the transcript of the call and you can have the breakdown of the next steps. But we do allow, persons, if they want to come in for the consult and meet with me in person, that's also fine. We find a way to record the call that way as well if you're in person, right? But online is preferred because then you can get a transcript of the call, and if you decide to retain us and you want to have that one-on-one meeting, sorry, battery going, then that's fine, right? So we do things very differently at our firm. It's a consultation is 45 minutes to an hour, and at the end of the session, within 24 hours, we give you the action items that you need to take, and you can go back to them until you're ready to get a retainer in place, right? But Greg, glad I could help you. Looks like I had a good timing here. If anybody else wants to come up, I don't know.
Good afternoon, my boss. Can you hear me?
I'm hearing you, yes.
Good. So I would like to take you back to my question that I asked earlier
Okay,
on.
sure, yeah.
It was about the side woman. So my question regards a scenario that we always see happen way too often in society. When the husband is deceased or passes on, then he gets to find out that there is actually a whole entire people get to find out that he's been living a double life. He has a
Yeah.
lady, he has children, and all that. So my question was, what does the law provide? Those other children who have been seeing this guy as dad, he's been providing for them, they've been dependents, do they get to benefit anything despite not being in the will or not even being known? Is
Yeah,
there
they
any
do.
recourse for them?
So it depends on how the will is drafted. So if there's like a residuary clause in the will, something can be done in that regard. But if there is a will and they were written out of the will, the most they could do is probably challenge it in court, and then allow the court to decide in that regard. But as it relates to the spouses, using spouses loosely, it can be that he was married twice, right? So it's really the person that he was married to that really has the upper hand in that situation. However, if there is a will, then there is an executor, right? And then the executor their job would be to carry out the wishes of whatever is in the will. And then most wills have what's called a residuary clause. So if, for example, reference is made to the house, car, you know, as you know, certain assets that are mentioned specifically in the will, then the residuary clause would capture all the other assets that were not mentioned in the will. And then the other children could perhaps make an application to benefit from that. But yeah, it's something that does happen. But usually I find that men that have double lives, they don't have a will. And so that's where the proof of paternity would come into play. So the children would have to demonstrate that. But like I was saying earlier, there must be mature people in the community that can say, yes, I know for a fact that John Brown was actually the father for Mary and Mark, for example. And they'd have to give affidavit evidence to the court and maybe even challenge the validity of the will altogether, right? So it's in a situation like that where the person has a double life, usually it's people that have a large asset base because it takes a lot to manage two families or to take care of two families, and so it might be worth their time. But it really is a difficult situation. What would make sense is for the women to work together to resolve it, and perhaps for like the executor, if there is a will, to use their discretion to cater to the other children that are not, may not be upfront or may not be, their mother wasn't married to the person, right?
Isn't that beyond the powers of the executor?
I think the executor has some amount of discretion. Their job is really to ensure that the interest of the estate is carried out. And so the executor does have quite a bit of discretionary power. And two, they're supposed to get, technically an executor should get compensation for their efforts. So, they may decide that rather than taking compensation, they may ensure that the other children are looked after, or, maybe if they still have years in school, they're still think they're looked after. But if there's a will in place, they'd probably have to challenge the validity of the will. And that would probably be the best way for them to actually get something or benefit from the estate in some way. Yeah. But where are you from? Your accent, your accent sounds South African.
I'm from somewhere in Africa.
Okay.
So
Okay.
I'm wondering though, what then happens if that person didn't have a will? Because if there's a will, we have somewhere to start from.
Yeah, you do, in the sense that you know what assets they have, but if there is no will, I feel like if there's no will, all the children are in a better position to claim for something, right? Because the will is usually specific. And this just going off of common law, which is what applies to Caribbean countries and African countries. So the common law says the spouse, and if the spouse doesn't want to act, then it's the children. So I'm guessing the children all meet each other at the funeral. And so if all of them decide to come together, it may take some time, then I feel like they're in a better position to apply together to ensure that everybody benefits. But then if one family is like, oh, well, we were the ones that, our mother was the one that got married to him, and then there's a problem there. But usually those men don't have wills, or they have they make some other preparation. They may add somebody's name to the bank account, or they may have an investment account and they add somebody's name to it unknowingly. They may not tell the person that they add their names. That's usually what they do,
Yes, polygamy is a bit expensive. If you don't have the money for it, just stick to one woman.
Yeah. But I feel like people like you who are, concerned about this, you see these things play out from time to time. You encourage your peers to do the right thing, or the right thing would mean you don't want anybody to know about your double life. Maybe have a joint account, maybe ensure that you have a life insurance policy that you maintain. Things like that. There are a lot of ways to manage your estate without actually having a will. if you really care to figure it out.
That's true. For our case, though, polygamy is legal in many countries out here,
Oh,
so
really? It is.
there's
So,
provisions for that. Yeah.
interesting. But isn't it a case where each family has to be treated equally? Isn't that how it goes? Like each.
Traditionally, culturally, yes, that's the whole point. You have to provide for both. I mean, when I say both, I mean just two, but there are scenarios where someone can have more than five wives and all that. It's normal. As long as you can afford it, go on and do it. But from what we usually see, the reality on ground, it seems like the more educated someone is, the less they're into that,
Yeah.
they know better. But you find those people that have quite a number of families and grandkids and all that, and well, everyone knows that those are their kids. They are all in the same homestead somehow, so they get a way to go about it. Yeah, it's
So is
practical.
it that these men that have multiple families, is it that, I don't know, somehow they're genetically superior, like their skin is perfect and they're 6'5"? Why women would sign up to start families with them knowing that they have several other families?
Well, for starters, it comes down to resources, and then
Okay.
also you could look at it from the point that this is marriage, so it's consensual. The
Yeah.
woman is aware that there's a family already existing. If they do not mind being a second or third wife, they can go ahead and engage in it. It's not something that's done in secret or anything like that.
Okay.
Yes, as long as you hear the gamy in the word polygamy, it's actually marriage. We're not talking about
Yeah.
cheating, we're
Yeah.
talking about actual marriage. Yes.
Yeah.
So it's consensual, two adults agree, yes, I'm up for it, I don't mind being part of it. And yeah, they go on with it.
Resources. Well, I mean, I would think that a lot of those numbers are declining. Most of the women I know from Africa, they're either attorneys like myself, or they're doing different things in government. So they're finding, so they're not. But you know what's funny? Some of them still end up in a similar situation. Like,
Exactly.
now that I think about it, sometimes
Yeah.
they end up being in situations where their partner is, all over the place, and
The baseline comes down to there'll always be more ladies than guys. So the demand is a lot more for the guys in one way or the other. And the
yeah,
busy ladies that you're talking about, they usually engaged in work and all that, so they don't have the time to entertain, I'd say,
yeah,
the husband. So he has no way of if he has no way of restraint. I mean, he can go out and do whatever he has to as long as he's not embarrassing her and all that.
yeah,
That's usually
yeah.
the arrangement.
But then
When are
somehow
you
they
coming
get
to Africa,
embarrassed, though. I don't know. Somehow the embarrassment, somehow, I think that, oh, it's like, oops. But when my battery is about to completely go, but
We
I should
continue.
be back. Yeah, it was great speaking with you, and I probably jump back on later this evening, which would probably be late for you, but same time tomorrow for sure.
Okay, you could give me a follow and share the link when you're online.
Absolutely, absolutely. Let me. I think I just followed you. Yeah.
Cool.
All right,
Have a
guys. Well, thank you
wonderful
for all your great questions and the engagement today. Please go and like the page, and I think this live should be saved, so I should be able to like share it on my YouTube or something like that. All right, bye.